qualified terminable interest. And a qualified terminable interest is something that the IRS has granted. We agree that this interest technically is a terminating interest. However, we are going to be allowed to tax it, and as a result, we're going to permit it. So the IRS is saying we'll tax it under these conditions and we'll permit it. The reason that this is so attractive to our clients is that it allows you to place conditions on the marital deduction. It's not simply the bypass trust now, where you can place the sort of limitations we talked about a few moments ago, and that may be the heart of your estate planning is your concern about these levels of control. Well, now you can extend that not only in this trust, but you can put it over here in your marital deduction trust. You can set up your marital deduction trust as a Q-tip trust, and that means it will qualify for the marital deduction. So you put an unlimited amount of money in there and still have controls. What controls can you have with a Q-tip? You can have your wife subject to a health, education, maintenance, support standard. It can be an income standard. It's a standard that allows you to assure that only a certain amount of the money will be used for her benefit, and then you can prescribe who the successors will be, who will be the successor beneficiaries, who will get the assets that are left. But now there are some limitations on the Q-tip. You can't choose to take advantage of the marital deduction and give her nothing. But you can limit it simply to the income. The IRS does require that you pay out in this Q-tip trust, remember, which relates to the unlimited marital deduction. With the Q-tip trust, you do have to pay out all the income, has to be paid out to the spouse, has to be paid out at least annually. That's really the key requirement, and there are some others, but I just want you to get kind of the fundamentals here. So the whole idea is now you can choose to design a marital deduction trust that's going to let you decide, who do you want the money to go to ultimately, and you're going to be able to protect yourself from a successor spouse. Maybe I shouldn't use the word successor spouse. Her second marriage, and these are concerns I'll tell you many of our clients have, because they worked hard and they really want their children and others to benefit, and at the same time they want their spouse, if she survives them, to be able to benefit as well. So how do you achieve all those goals? And a Q-tip is a good way to do that. So remember, you can choose to pay out more than simply the income if you want. You can give her certain invasion powers called rights of withdrawal, up to $5,000, 5%. You can give her a large amount of control, or you can give her very little control, but at a minimum you've got to pay out that income. Now let me say one other thing, shifting over to the other side of the spectrum in terms of your concerns. Sometimes our clients have complete and total trust in their surviving spouse. I'm tempted to say naively, but nonetheless, you have to make that decision. And the reality is, in some cases, you don't really need to worry about these issues that I've talked about here. Maybe your entire concern relates to taxes, and that you don't really have an asset management issue. You think your wife is fully capable of taking care of the estate after you and preserving it and using it in a way that's consistent with your priorities. If that's the case, then you want to still have a bypass trust, right? Because that serves a purpose unrelated to tax, to the asset management side. It serves a tax purpose too. So you want to create a bypass trust, but now your objective is to give your surviving spouse as much access as possible. How do you do that? How do you give her the money and not give her the money? So in that case, you're reaching to give her as much access as possible into your bypass trust, the opposite of what we were just talking about. And in that case, certainly, the marital deduction those funds would go to her probably entirely with no trust at all involved. And she would manage them as she chose, and what she used up during her lifetime would never be taxed, and what she didn't would be. But as to your bypass trust, you may say, well, gee, how far can I go in terms of giving my wife control over these funds? Well, believe it or not, you can actually make her a trustee, and this will not cause the funds to be pulled into the marital deduction trust, or regarded as marital deduction funds. But you have to be careful there. You've got to have limits on her, and then that raises again for us those requirements about the health, education, maintenance standards. There has to be an ascertainable standard. That's the phrase at the end of the day that has to be met. There has to be something that an independent forum, a judiciary, a judge, can look at and say, yeah, this is a standard that would limit the way in which she uses these funds in a meaningful way. And if there's not, then it's all a ruse. And the bypass trust really isn't meaningful, and the funds should be regarded as marital deduction funds. So you want to, if you place her as trustee, you've got to place some real limitations on how the funds are used. And the HEM standard, the Health, Education, Maintenance, Support Standards, is generally regarded as sufficient for that. And in doing that, she can also have another power that's permissible. She can have the ability to withdraw on an annual basis the maximum of $5,000 or 5% of the principal value of the trust. That's in addition to what she can take out under the Health, Education, Maintenance, and Support Standard. Certainly she can take out income. So you can give your surviving spouse a lot of control over this bypass trust. So by no means do I want to suggest that this is always a road you go down to control her or limit her access to these monies. It can be the opposite. So there you have it. This is just a general overview of estate planning for a married couple. You'll hear a discussion of the AB trust, the Q-tip trust, unlimited marital deductions. So hopefully now when you meet with your lawyer and you start that discussion, you'll be much better equipped to understand what's going on. Now we'll revisit these issues as we go along. Certainly there's a lot of flesh we can put on the skeleton. But what I want to do next week is I want to go back a little bit in time and let's see what we can do in advance of the marital deduction planning, the planning for what's going to happen with those funds at your death. See what we can do in advance of that to reduce the taxation issues as well as to deal with control issues. We'll talk about transfers you make during your lifetime, whether you do a sale, whether you do a gift. We'll talk about some of those transactions. And again, I won't be able to get in a lot of detail, but my objective, remember, is not to prepare you to draft your own documents. What I want to prepare you to do is be an effective client in working with your attorney when you do estate planning. So I hope this was helpful to you. My name's Joe Cordell. This has been another episode of Cache Counsel. Take care.